So hello, everybody. I hope you can hear me. I would like to welcome you to this webinar on the protection of the environment in times of armed conflict. My name is Finn Stepputat. I'm a senior researcher here at Danish Institute for International Studies, and I will be chairing this webinar. And I will start by giving the word to Jairo Munive, who's an independent researcher who has been organizing this webinar. So I'll let him introduce the webinar and the speakers. Thank you.
Thank you, Finn. To all of you, it is a pleasure to have you online for this webinar. It is a pleasure to have you online for this webinar about the protection of the environment in times of armed conflict. Up to the webinar, Finn Stepputat, senior researcher at DIIS, and I wrote a brief pointing out recent policy, legal, and research initiatives around the protection of the environment and conflict. You can follow the link in the chat to read the brief. In this brief, we identified key stakeholders working on protection of the environment during conflict. They are here with us today. The Conflict and Environment Observatory, the International Committee of the Red Cross, and Geneva Call. Let me say a few words about the panelists, their institutions, and their work. First, Doug Weir and CEOPS. Doug is the Research and Policy Director at the Conflict and Environment Observatory, CEOPS. CEOPS has followed for several years the work of the International Law Commission, ILC, on the development of the principles for the protection of the environment in relation to armed conflicts. CEOPS has accumulated throughout the years invaluable knowledge in the field of environment and conflict. Our second speaker is Vanessa Murphy, Senior Legal Advisor at the ICRC in Geneva, International Committee of the Red Cross. Her present work focuses, among other issues, on the protection of the environment in armed conflict, and she is the co-author of the ICRC's guidelines from 2020 on the protection of the natural environment in armed conflict. Our third speaker, Hiba Mikhail, is the Regional Legal and Policy Coordinator for the Near and Middle East at Geneva Call. Hiba has extensive experience engaging local and regional stakeholders, including armed groups and de facto authorities, in the protection of civilians in armed conflict. She will introduce us to the operational challenges when dealing with armed groups and environmental issues. Until now, the environment has not been a key issue when engaging with armed groups and de facto authorities, a situation that might change in the near future. Our first speaker is Mr. Doug Weir from CEOPS. The floor is yours. We will have 10 minutes for each speaker, followed by 10 minutes for question and answers from you, the audience, and questions for each organization. Welcome, Doug, and a pleasure to have you here.
Thank you, Jairo. Thank you, Finn. Just let me check. Excellent. Okay. Yeah, good morning, good afternoon, good evening, as the saying seems to go these days. A quick thank you to the Danish Institute for International Studies for the invitation to contribute today. As with Vanessa, last week we were in New York for the final UN General Assembly 6th Committee debate on the International Law Commission's decade-long study into how the framework protecting the environment in relation to armed conflicts could be strengthened. I think more than 50 states engaged with the debate, and the general tone was positively constructive, although it obviously wasn't universal, and some states still have lingering objections to particular components of the principles or their commentaries. Today I'll provide just a quick overview of the principles themselves and a question of what happens next. So just by way of introduction, CEOPS and its predecessor organisation have been contributing to the PERAC process for most of its duration. And that's from reporting on 6th Committee debates to examining how the principles might work in practice based on our conflict monitoring work, and to undertaking the first ever stocktakes of national PERAC practice. We've also worked to communicate the aim of the PERAC process to legal and non-legal audiences. So the International Law Commission advises the UN General Assembly on the progressive development and codification of international law. Its PERAC study, which began in 2013 in response to a request from the UN Environment Programme, represents the most significant advance in the legal framework protecting the environment before, during and after armed conflicts and in situations of occupation since the 1970s. Its output will be 27 principles that have been informed by international humanitarian law, international environmental law, human rights law, international security law, and the practice of states and international organisations. The principles are a mixture of binding and non-binding obligations, and as civil society we view the principles as a vital normative framework that establishes a minimum standard of environmental conduct across the cycles of armed conflict. Naturally, this is a standard that can and should be built on further. However, the principles will only achieve this goal if they're endorsed, promoted and implemented by states and a range of non-state stakeholders. So we also need to look ahead at what we can collectively do to bring the principles to life. So the principles are part of a wider PERAC landscape, which includes the ICRC's work to update its guidelines for militaries, principles on the protection of water infrastructure, and principles for victim assistance from the toxic remnants of war. In the next few slides, I'll draw out a few key themes that are important considerations for PERAC implementation. So I think the first thing to think about is that environmental harm in relation to armed conflicts is better documented than ever before, and the importance that we place on environmental protection has grown and critically will continue to grow. While external factors like the environmental consequences of the invasion of Ukraine or 3 decades ago the burning oil fields of Kuwait can shift policies and positions, there's enormous value in having a forum for ongoing discussion and dialogue. Our understanding of how the environment is impacted, both directly and indirectly, continues to develop, and the more we understand about these impacts, the better place we'll be to identify policies to prevent or minimise harm. The PERAC process and the 6th Committee debates have been invaluable for exploring the environmental dimensions of armed conflicts. This has also been true of recent UN Environment Assembly resolutions and other initiatives. It's forced states to identify and take positions, and in many cases to begin engaging with civil society, and also with the realities of environmental harm. We shouldn't minimise the importance of this for a topic that is often sidelined or only addressed obliquely in both environmental, humanitarian and security fora. So this begs the question, once the principles are adopted, how do we keep this dialogue going? While it's in the International Law Commission's power to propose new conventions, the PERAC process will not conclude with a new treaty on conflict and the environment. Instead, we have its softest output, principles. But just to confuse matters, the principles are a blend of pre-existing binding obligations and non-binding obligations, as well as best practice. But it's their temporal and thematic scope that makes them incredibly valuable, normatively speaking. The Commission suggested that implementation should be left up to states, and right now this means that the principles have no clear custodian, nobody charged with supporting implementation. But in this challenge we also have an opportunity. So back in 2020, and with the support of Finland and Norway, we explored what kind of implementation vehicle might be appropriate for the PERAC principles. We found a number of models and approaches that could be used to promote their universalisation and implementation. And throughout, the need for that something was readily apparent, something to breathe life into the principles. We should not sit passively in the expectation that they will be implemented. Happily, we're already seeing conversations beginning about how individual principles could be developed and implemented. There's also the broader question of how the implementation of the wider PERAC landscape could be monitored and promoted. Naturally, there are risks with a solely piecemeal approach. There's a long way to run. It's obviously just the very start of this process, and there's already a lot of enthusiasm out there from the legal and PERAC communities. So the PERAC principles are intended to apply to both international and non-international armed conflicts. Moreover, there are a number of principles that directly address both state and non-state stakeholders. These include international organisations, business enterprises and civil society organisations from a wide range of backgrounds. Add to this states and their different components, be they ministries of defence or environment, and non-state armed actors, whether private military and security contractors or armed groups. These interactions suggest a broad and rich foundation of stakeholders whose engagement on environmental protection through the PERAC principles would be an important component of an ongoing implementation programme. Given the number of non-international armed conflicts, where the conduct of non-state armed groups is an important determinant of environmental harm, non-state armed groups represent a vitally important yet currently under-addressed constituency for future PERAC implementation. When we reviewed potential implementation models, one thing was clear: it would need the buy-in of a group of like-minded states, states that supported the twin goals of reducing environmental and civilian harm in relation to armed conflicts. It would require leadership from states. In this, they would be assisted by a growing number of stakeholders, including civil society organisations and academic experts. And one important and straightforward task would be promoting the principles in relevant international processes and fora, whether these are security-focused or whether they address the environment. Other potential areas for consideration by such a group might include the role of the UN General Assembly in promoting the principles, as well as implementation at home via domestic military manuals. Having reviewed the national practice of 2 states, we can say that many states are probably more aligned with the principles than they think they are. And for those that aren't yet, the sharing of best practice on implementation between states would be another valuable role, as would engagement with those non-state stakeholders addressed by the principles. I'll defer to more informed members of the panel about the prospects of state engagement with non-state armed groups on PERAC. But as far as the process and national positions are concerned, the focus has been primarily on whether a principle could be identified outlining the accountability or responsibility of non-state armed groups for environmental damage. In the end, the Special Rapporteur concluded that there was insufficient practice to develop one. Alongside that, we've also noticed an increasing trend in the politicisation of the environment in the context of armed conflicts. This is perhaps a reaction to growing public environmental awareness on the need for protection, but it's something that requires further research, and it may well impede the potential for engaging with non-state armed groups in some conflicts. To conclude, the PERAC principles have the potential to be a vital normative framework that establishes a minimum standard of environmental conduct across the cycles of armed conflict. There's enormous value in supporting ongoing dialogue on environmental protection in relation to armed conflicts. Absent a custodian, there's a risk that the PERAC principles will not reach their potential, and it's up to us, all of us, to breathe life into them. Work is already beginning on developing specific principles, and whatever model or models are chosen to take implementation forward, a group of like-minded states will probably be vital. Because of the scope of the principles and their applicability to international and non-international armed conflicts, non-state armed groups should be important stakeholders in implementation. But the prospects and modalities of that remain to be explored. So thank you for listening. I shall leave it there.
Thank you very much. That was a great introduction. Now we have some time for questions for you. We have one here, actually. So it's about the legal efficiency. So the question is, how far are the principles and expression of customary international law? And do we have any examples?
Yes, it's a good question for a lawyer, I think. So the principles are, I'll maybe answer that somewhat obtusely. So I think the principles are kind of a heady blend across the 27 of them of reflections of existing treaty obligations and customary law, with some components of that being pushed and tweaked a little further than previously been the case. Similarly, the principles on occupation are a really great example of evolutionary interpretation of what is quite dated now, occupation law. I think probably the most interesting and exciting ones, at least those which kind of got the most pushback from states, beyond those states who were concerned at any attempt to interfere with IHL or meddle with it or develop it in any way, were maybe the principles around business enterprises and conduct of business enterprise in areas affected by conflict, which speaks to the debate going on elsewhere around business and human rights. So that was an area of particular interest and progressive development, I think, which didn't entirely answer your question, but that was a non-lawyer's answer.
I don't have any questions right now, so maybe you, Jairo, could chip in.
Yes, indeed. Thank you, Doc, for the presentation. My first question is regarding the principles. I would like to ask you, What states are more in line with the Perak principles? And secondly, what are the aspects of the principles that have been most criticized by states? Thank you.
Yeah. So I'm just thinking there. So there's been a range of interests. So there's been maybe 35, 40 states who've been fairly vocal in the process throughout. There are just a handful of states who have had almost no or very few objections. So for example, the Nordic governments have been very supportive throughout. There are some states whose positions have changed because the process has been going on for 10 years. So for example, Spain, at the start of the process, they were extremely sceptical about the need for it and issued a number of statements to that effect. By the end of the consultation before the second reading, Spain were criticising the principles for not being progressive enough. So there are other countries like Russia who remain opposed, say that they are only interested in, or primarily interested in, protection of civilians rather than the protection of the environment. Make of that what you will. And then countries like the UK, well, nuclear weapon states essentially, who have particular persistent objections around components of IHL relating to the environment, which relate to their freedom to use nuclear weapons. There are other countries which have had specific objections to specific principles. So, for example, Vietnam have been very progressive and supportive of the principles as a whole, but had a number of criticisms around the principle on indigenous people in relation to their own national context. Similarly, France also criticised the principle on indigenous people because they don't recognise indigenous peoples. Everyone is French under the Republic. So it's a really kind of interesting heady mix, and you can maybe get a sense of that. There's a report we did earlier in the year which looked at all the written submissions which states had put in, which were like 20 or so submissions, and reading through those will give you kind of an idea of how states have been engaging with these principles. But yeah, there are very few who universally accept their full content. And then there are obviously, for example, the US, which is one which is maybe relevant to the discussion today, who called out just a few days ago why business enterprises had been singled out in the principles and not other non-state actors like armed groups, for example, and bad actors, as they call them. So yeah, it's quite interesting, and they reflect very much sort of state interests.
Okay, thank you. There is another question here. It says, have you seen more examples of the principle of distinction not being observed in recent disputes? For example, water pumping stations targeted intentionally. So maybe you could also just briefly tell what the principle of distinction means in this connection.
Oh, it's a great question for Vanessa. So this is the need to distinguish between military and civilian objects. So I think, as Vanessa will discuss, there is how the environment is viewed as a civilian object. Vanessa, would you like to take this one? It seems relevant to your interests.
Sure, yes. So the principle of distinction is an IHL rule. It's kind of one of the core principles of the conduct of hostilities of IHL. And the ICRC considers it to be a customary IHL rule. So it applies to international armed conflicts between states and non-international armed conflicts, meaning it also binds non-state armed groups. And it requires that at all times there's distinction between lawful military objectives and civilian objects. And the environment in general is civilian in character. And what that means is, unless a specific part of the environment has been turned into a military objective, so an example of that might be a tree that is hiding a fighter, right? Hiding behind a tree. Maybe in that specific instance, a part of the natural environment has become a military objective. And in that case, it would be lawful to target it, subject to the other rules of IHL, placing limits on how it can be targeted. But in general, the environment is civilian in character, meaning it cannot be directly attacked. Meaning that in some circumstances, it might be a war crime to directly attack the environment in the same way that it's a war crime to attack civilian objects, such as schools or hospitals in situations of conflict. So that's the meaning of the rule of distinction, and it's set out in Principle 13 and Principle 14 of the ILC principles, and maybe back to you, Doug, on examples related to the question.
So, thanks, Vanessa. That was indeed far better an answer than I could ever have given. Yeah, I think we've maybe seen. Yeah, I think the question. I'm just thinking back to recent events in Ukraine and the deliberate targeting of infrastructure, which is the civilian population depends on energy infrastructure or hydroelectric infrastructure, and that's a clear case where there is no distinction being made between what are civilian objects and what are military objectives in the context of the conflict. So I think it's a common issue across many conflicts that we look at.
Okay, thank you. We have time for one more question, so maybe Jairo, you have one?
Yes, Doc, I wanted to ask you about the implementation levels of the Prague principles. There's a lot of talk about localizing humanitarian aid, and I was wondering if the solutions needed here to implement the principles are not quite localized. The question is then, are we talking on the right level, for implementing the Prague principles?
I think that's a really interesting point. Yeah, I think we definitely need the top level side. We need people to be aware of them. At the moment, although this process has been going on for 10 years, it's fairly niche, right? Even within the legal and international law community, and we need that to change. So that needs these principles to be raised in the context of different processes and different fora, and for them to be almost a reference point that people come back to when discussing environmental protection in conflicts. But then beyond that, and obviously beyond the text of the principles themselves, the commentaries, which obviously have been developed over the last 10 years, but knowledge develops and knowledge grows. And while a lot of people were consulted and a lot of states and others engaged with the process to develop the commentaries, there are still a lot more voices and a lot more perceptions out there who can contribute to this question of how we implement them and what implementation actually looks like on the ground. And in a lot of these cases, actually it's the people who are on the ground who have the best understanding of how the environment is damaged and what specific policies could be put in place to prevent them in order to ensure that the purpose of the principles are implemented.
Okay, thank you very much. I think maybe we should save the further questions for the general session at the end. So I would like to give the word to Vanessa. Please take the floor.
Great, thank you. And I'm just going to share my slides. So let me know if you can just nod if you can see them okay. Yes, great, wonderful. Okay, so thank you very much to Doug for giving such a good overview of the ILC principles. And so the focus of my remarks today are how the ILC principles are complementary to the ICRC's work on the same topics, on the protection of the environment in armed conflict, and also how we might be able to move implementation forward quite specifically on some of the principles that apply during armed conflict. So what I'd like to do in order to get into that is speak about these 5 things. So first of all, zoom in on the principles that apply specifically during armed conflict. Then explain from our perspective really why these matter, why it's important to be speaking about this in 2022. Number 3, introduce the ICRC's work that complements the principles applying during armed conflict, and specifically our guidelines on the protection of the environment in armed conflict, which go into some further detail on some of the rules spelled out in the ILC principles. And then number 4, zoom in quite specifically on principle 14, so on the conduct of hostilities rules and the legal limits of how parties can apply the conduct of hostility rules to the environment as they fight. And then finish number 5 with a few reflections on how to move forward on implementation. So to begin, as Doug said, I'd like to emphasize that these principles are a historic contribution to both the clarification and the strengthening of international law on the environment in armed conflict. And as Doug said, and I agree, really this is the most significant milestone the international legal community has had in this area, probably since the 1970s. And that is, first of all, an exciting thing for the legal community, and second of all, additional motivation for the wider legal community, not just international lawyers, but also those working on this issue at domestic level, civil society, armed actors, to start paying more attention to this issue as it will become more important in years to come. So a very significant achievement by the International Law Commission. So of the principles, there are, I forget now, I keep thinking it's 27 or 28. It's either 27 or 28 principles. And of these, they apply before, during, and after armed conflict. And the ones that apply during armed conflict are principles 12 to 21. So essentially the principles that apply during, drawing quite specifically from IHL, 12 to 18, and then the principles applying in situations of occupation, which is also a form of international armed conflict. So really the principles 12 to 21. And to give an example, go through a recap of what these address. So this includes rules on the widespread, long-term and severe environmental damage that can be covered during armed conflict. In the view of the ICRC, this is a customary law prohibition in international armed conflicts. It's also the application of the principles of distinction, of precautions, of proportionality to the environment. It's the prohibition of reprisals against the natural environment, prohibition of pillage, and rules on how an occupying power must govern the environment in an occupied territory. So these principles, so principles 12 to 21, are of primary relevance to states and non-state armed groups. They also, many of them, apply to non-state armed groups who are fighting armed conflicts, so who are parties to armed conflicts right now. So in a nutshell, they set legal limits on how parties can conduct hostilities and occupy territory, including in contemporary armed conflicts. And why these matter, I would say there's kind of three buckets of why these matter, or the way that we think about it at the ICRC. First of all, because of the damage that is caused to the environment in armed conflict that we have seen, as Doug said, really since Vietnam, but quite consistently since then. So attacks damage the environment directly if the environment is specifically targeted, but also incidental damage that occurs, for example, when chemical facilities or industrial facilities are targeted, then various types of land or contamination, whether it's water, soil, or other land contamination, take place. Another aspect of this is biodiversity. So the IUCN released a report last year, or not that long ago, and they found that over the last 70 years, humans have waged war in many of the world's most important places for biodiversity, including regions that hold many imperiled species. And when you set this against the wider work that is being done at international level to document how biodiversity is crashing in an unprecedented way, then we understand that the issue of armed conflicts fought in biodiversity hotspots is becoming more pressing than ever, because the damage that is done in many cases will be irreversible. Explosive weapons also leave behind toxic remnants of war that take years, if not decades, to remedy, and damage facilities containing a range of other pollutants, which again create further pollution. So long story short, the way that wars are fought today create a huge amount of direct and indirect damage to the environment. Second point on this is, for the ICRC, this is a protection of civilian issue. It is not a separate issue from the protection of civilians. When the environment is damaged, conflict-affected populations bear the cost. And that's very intuitive, right? Because we rely on the environment for food, we rely on it for water, we rely on it to keep in good health, and generally we rely on it for livelihoods. So that could be fishing, it could be agriculture, farming communities. Essentially, if the environment is damaged, civilians will also bear the brunt. So really, it's important to think of the environment as a protection of civilian issue. And the third and final point on why this matters more than ever in 2022 and why the ILC's work is so timely is that the climate crisis is rendering the environment all the more vulnerable and creating additional risks on populations in conflict. So the ICRC has looked at the ND gain index, and we've concluded that 15 of the 25 states that are most vulnerable and least ready to adapt to climate change are also experiencing armed conflict. So it's this confluence of conflict, environmental degradation, and climate change that are exacerbating each other, and means that the environment is all the more fragile and at the same time all the more precious. So those are in a nutshell why we think that this issue is particularly important to speak about in 2022. Next point is how these principles that apply during armed conflict can be complemented, or we feel have very much complemented the work the ICRC is doing in this area. In 2022, we released our guidelines on the protection of the natural environment in armed conflict. They set out 32 legal obligations and policy recommendations specifically under international humanitarian law. So as Doug said, the ILC's principles are much broader in that they look at international law that applies prior to, during, and after armed conflict, and they draw on a wider body of law. So environmental law, human rights law, they look at how these bodies of law work together. Whereas these guidelines focus very specifically on international humanitarian law, they contain many of the rules that the ILC principles do as well. So principles 13, 14, 15, 16 are also elaborated on in this document. And what they do is they explain in greater detail how those rules can be applied by parties to armed conflict. So what does it really mean to that disproportionate damage against the environment is prohibited? What does that look like in practice? Are there examples? So this document is complementary to the ILC's principles and is intended to be a resource for states, parties to armed conflict, and other actors who engage with, implement, and apply IHL. Its purpose is really to facilitate the adoption of concrete measures to enhance the respect for IHL's protections of the environment, and those speak to the ILC principles 12 to 18. I'd like to just, before moving on to reflections on implementation, I wanted to zoom in and spend a moment talking about ILC Principle 14. So this is built on the civilian character of the natural environment and the application of the conduct of hostility rules to the natural environment. And the principle says, the law of armed conflict, so also known as international humanitarian law, including the principles and rules on distinction, proportionality, and precautions, shall be applied to the environment with a view to its protection. And this is an extremely powerful rule because these rules of IHL, distinction, proportionality, and precautions, are the ones that are applied probably the most commonly in contemporary armed conflicts, almost on a daily basis. So if we can really ensure that that rule is applied to take account of environmental damage in a greater degree than it is currently, that has the potential to change behavior and to reduce the scale of damage that we see in contemporary armed conflicts. So the ICRC guidelines provide additional detail on how that rule can be applied. To give an example, the guidelines commentary, paragraphs 114 to 122, speak about the different factors that should be taken into account when applying that rule. So, for example, the obligation includes, or rather, sorry, one moment, I'm just going to, I'm so sorry, my screen has frozen. There we go. The obligation includes taking into account an attack's indirect effects on the natural environment. And what that means is that indirect effects that are reasonably foreseeable to a party to armed conflict must be taken into account in conducting a proportionality assessment, meaning a proportionality the proportionality of the damage that is going to be caused against the military gain that will be achieved by a particular attack. And in that respect, what should be taken into account is information from all sources available at the relevant time. So that can include information that is provided by civil society or environmental experts who are available on the ground, who are making that information available to commanders, and also informed by past practice and empirical data. So what that means is that fighting forces should be learning. If they have consistently attacked a particular type of objective and they know that the damage that will be caused is long lasting, they have done so in the past, then that is the kind of information that should be taken into account with respect to the indirect effects of an attack. Information regarding the long-term risks attendant to the disruption of ecosystems is going to also increase as the global community gets better at documenting this kind of damage. So when we think about the Vietnam conflict in the 70s, a lot less was known about how long the damage would last, how widespread the effects would be, whether they would have long-lasting health impacts also on the civilian population. So we knew a lot less in the 70s. Now we know a lot more. And what that means is that we should be able to draw conclusions about whether something is severe, whether something is going to have a long effect. And that kind of empirical data should be informing the conduct of hostility decisions made by warring forces. There will, of course, be different weights to different types of damage in proportionality assessments. So, for example, a damage to sand in the middle of a desert is going to probably weigh a lot less in a proportionality assessment compared to an important water source or a particularly biodiverse area. And an example of disproportionate incidental damage might be, for example, burning down an entire forest to eliminate a small enemy camp. And an example from history was that generally it was felt that the deliberate spilling of millions of gallons of oil into the sea during the 1990 to 1991 Gulf War was excessive, so was disproportionate. So that's kind of an example of history where we've generally the international community considered that that kind of damage was disproportionate and therefore unlawful, specifically with respect to the environmental damage that was caused. So final reflections with regard to how we can implement these rules. And on this, I will say that, we know that the law is violated very frequently. But the example that I use when people sort of shrug their shoulders and say, is it really worth it? What's the value of having these principles if they are not respected? Is the example of a speed limit. So speed limits are often violated. We probably all violate them on a daily basis. Nevertheless, even though they are often violated, we still feel that they change behavior and they have the capacity to save lives when they are respected. So in the same way, these rules, if they are better known, if they are better implemented by states and parties to armed conflict, have the capacity to change behavior. So our asks at the ICRC is that, number one, states and other actors have more work to do to integrate these obligations, so the ICRC guidelines and also now the ILC principles, into military doctrine, military manuals, into their training and national frameworks, so that they have the capacity to take environmental damage into account as they fight. Second, we recommend that they should also adopt and implement measures to increase their own understanding of the effect of military operations on the environment. It is sometimes understood to be a relatively new area of law. We know how injuries to civilians happen. We know a lot less how damage to the environment can last. So have militaries improve their understanding of how the environment can be damaged. And that can be done in a few different ways. So for example, to give some examples of this, military personnel involved in planning operations could seek advice from environmental experts, including civilian agencies on the ground. Post-strike battle damage assessments are a good practice that many militaries conduct after a specific military operation. They generally do not look at environmental damage. So they will assess civilian damage to civilians, damage to specific types of civilian objects. They often don't encompass environmental damage. So that could be a new practice that is adopted. And third, for example, when weapons are reviewed for their legality, consideration could be given to their effects on the environment. Number 3, we also recommend, and this is in Principle 4 and 18 of the ILC principles, that parties to armed conflict consider identifying and designating areas of particular environmental importance as demilitarized zones. So where the environment is particularly important, particularly fragile, consider taking combatants, taking military objects, taking military operations out of those zones to reduce damage from the outset. And fourth, exchange good practices. And in this respect, and I'll end here, we know that this is a growing area, that some states have extremely good practice. As Doug mentioned, many states actually have quite a lot of environmental aspects integrated into their planning, integrated into their military manuals. So there are states with plenty of good practice, and there are some states who really don't consider it very much at all. So there are opportunities to exchange, to improve. It's pretty nitty-gritty and boring, but I think that that's where a lot of attention is needed. And in this respect, next year in February and March, the ICRC in Switzerland are co-convening an expert meeting amongst states precisely for this purpose, so to exchange good practice on how the environment can be integrated into military operations. So I will leave it there, and thank you very much.
Thank you, Vanessa. We have a couple of questions coming in. So the first is, isn't there a risk of overstressing the civilian character of the environment within the guideline PIRAC guidelines, making the whole exercise to be superfluous? I guess it applies to the ICRC guidelines as well.
I think I guess I will answer the question in 2 ways. So the first is that from a purely IHL legal angle, the logic of IHL is that something is either a lawful target, a military objective, or everything else is civilian. So there's no gray area in between. You cannot be sort of not a civilian object and not a military objective. So by the pure logic of IHL, if the environment is not civilian in character, that means it could be lawfully attacked. But there's very specific criteria around what is a lawful military objective. It must be providing direct and concrete contribution to military action. So in terms of the pure IHL logic, it doesn't really make sense for the environment to be sort of a gray area in between. There are plenty of arguments that have been made that go in that direction, also towards combatants, that they're neither a fighter nor a civilian, they're something in between, and therefore no law applies to them. So for the ICRC, it's pretty clear from an IHL perspective, it's just logic, something either is a military objective or not. I think what your question gets at, though, is it realistic? Is it pragmatic? Will parties to armed conflict listen if we speak about the environment as on par with civilians? So are you really telling us that we can't attack a field and instead we need to think about attacking a hospital or a school or so on and so forth? So are you putting it on par with these really important life-saving emergency civilian objects? And to that, what we feel is that, first of all, of course, you can make differentiation. So that's what the proportionality assessment is for. As I said, different types of environmental harm will matter differently in the calculation and planning of how military operations take place. So the environmental damage that is caused in a desert really is not going to weigh the same to civilian damage that is caused to a hospital. Certainly not. So we're not saying that it's equivalent. We're saying that an assessment needs to be made. And second of all, what we have seen over the last 30 or 40 years is that the environment if it is constantly just disregarded completely from military considerations, what that means is that we end up in a situation where 20 years down the line, civilians do not have food to eat. They must move. So human mobility increases because there has been considerable damage to their livelihoods, to agriculture. And the climate crisis is really driving this home. So conflict-linked environmental damage in places such as Iraq, in places such as Niger, has become really exacerbated and has now made just subsistence for civilians much more difficult. So I would say that not including the environment in military considerations now is essentially kicking the can down the road and will make any kind of reconciliation, any kind of development extremely difficult in the next 10 to 20 years.
Okay, thank you for that. That was very extensive answer. We have two more actually. Let's take one now. It's from Colombia, and it says the Amazon basin is facing high rates of logging. Some countries, such as Colombia, has declared a war on deforestation, which is part of the greening of the military approaches seeking to protect the environment. Do you have any thoughts of this type of approaches through the lens of the international humanitarian law? Vanessa?
That's a very interesting example. Thank you for sharing it. I would say that, and I wonder if Doug has anything to maybe add to this, my reflections. The logging and the fact that logging can sometimes increase in situations of conflict from the IHL perspective tends to be an indirect effect of conflict, right? So it's not damage created by hostilities. And so for IHL, it's not necessarily directly relevant depending on the circumstances. So I feel like from an IHL perspective, I'm not sure I have a massive amount to add very helpfully. I would maybe just add that in terms of the environment being a cause for increased military action, or the environment being a cause for new ways of the military planning, maybe engagements that are below an armed conflict threshold. What the ICRC sees there is that sometimes there's an overly simplistic link between the environment and climate causing conflict. And that is a simplistic link that actually requires a lot more nuance. And often when the military gets involved, it might be because, or rather, we should also be looking at different factors such as what are the economic factors that are surrounding that? What are the corporations that are involved there? What are maybe the social indigenous communities involvement? So in a long story short, just to say that it's sometimes a simplistic link that is made. Okay, the environment is being damaged and that might cause more conflict, or climate change is increasing, that might cause more conflict. And actually there's a lot more going on there, and there are many more factors to consider if we're thinking about how to prevent increased or prevent more harm.
Doc, do you have any comments?
Yeah, I'd be happy to just jump in briefly, because I think it's a really good example of why we really need to have a much better understanding of how non-state armed groups, non-state actors interact with the environment. So in Colombia during the conflict, the presence of the FARC and to an extent the ALN was provided some protection to rainforests in Colombia, and following the peace agreement and the removal and dissolution of the FARC to some extent, this then allowed a huge increase in rates of deforestation, not only in unprotected areas but also in protected areas in Colombia. And actually it's a very good example of why we need protection during conflict, but actually the approach of the ILC, which has accepted that the environment can be affected across all the cycles of conflict, is really important, because what we see in Colombia is actually very common in most other countries with high rates of tropical forests. You see very high rates of deforestation post-conflict. So Sri Lanka is another good example of that. On the wider question around military greening and green militarization, yeah, I think it's incredibly important that it's not seen as a first solution to these problems, and that the underlying issues which may be driving, which may be subsistence farming and subsistence economies of communities, why people are poor, why people are left out of economic models, why people are left out of peace agreements, this needs to be addressed first rather than immediately sending in the military. And also in some cases we see, for example, anti-poaching patrols in other countries, you see this question of it blurring the line and leading to escalations between poaching groups and militaries or militarized conservationists who go in to protect these areas. So these things, there has to be a huge amount of oversight, public oversight and transparency, and there has to be accountability if you are going to use these approaches in these contexts to protect the environment.
Okay, thank you, Doug. There is one more question, but I think we'll save it for the general discussion, general Q&A, and then pass on the word to Iba, who now we go from the kind of the policy level and legal discussions to a much more practical intervention. So we're looking forward to that. Iba?
Thank you very much, Finn. So it's my pleasure to speak on this panel today and bring in some of the operational aspects related to Geneva Coal's work on the protection of the environment. So as some of you may know, Geneva Coal is a field-based, neutral, impartial, and independent humanitarian organization with a unique mandate and mission to protect civilians by strengthening the respect of humanitarian norms. So we're speaking about human rights law as well as international humanitarian law by armed groups and de facto authorities. So as we've just heard from the fellow panelists, armed conflict contributes to environmental degradation in multiple ways and with long-term consequences, including displacement and food insecurity. Therefore, it's very welcome that there are indeed a series of ongoing efforts to strengthen and clarify the protection of the environment in armed conflict. And it is important to consider and involve armed groups in these ongoing debates and discussions in order to effectively protect the environment in armed conflict. And that's important for several reasons. First of all, the nature of contemporary armed conflicts, which are mostly NIACs, so non-international armed conflicts, and involve or include armed groups by definition. Moreover, also the number of active armed groups in conflict setting around the world. We've seen a massive increase over the last decade of armed groups active in these conflicts, with more than 600 currently active worldwide. And the third reason is also because the international legal architecture is tailored to state actors mostly, and makes it very difficult for armed groups to be part of lawmaking or policy-making processes. But rather than talking about these legal and policy aspects, which were very well outlined by the fellow panelists, I would like to delve into practical aspects of relevance to this discussion. So undoubtedly, as it is the case for other parties to conflict, armed groups may also resort to practices that negatively affect the environment. For example, through unsustainable exploitation of natural resources, poaching and hunting, which was just referred to by Do as well, the use of certain weapons in the conduct of hostility, namely explosive weapons or landmines. This said, armed groups can also be part of the solution. So by adopting protective measures and policies and putting them into practice, both in terms of conduct of hostilities, as mentioned by Vanessa, so looking at the principles of distinction, proportionality, and precautions, but also in their governance of the territories or resources under their influence. So the question is really, how can we meaningfully engage armed groups and de facto authorities to improve the protection of the environment in armed conflict? So as it is the case for states, we can use IHL as an entry point to engage armed groups on this thematic, with some additional legal and policy considerations that may be relevant for them. For example, the question of the capacity of armed groups to make an informed assessment of the potential environmental impact of their activities. So during the conduct of hostilities, how are they really able to assess, while the conflict is ongoing, what the impact of their activities will be on their environment, including on the short term or also on the long term? So there are many arguing that we should also use the concept of a sliding scale of obligations to the issue of the protection of the environment, as it is done in other areas such as human rights. So similarly, there is also another question, which is whether and to what extent is it useful to rely on state-centric legal frameworks to engage armed groups, and if we don't really need to have a bit of a shift in the way we address and engage armed groups in that matter. Whatever the case, we can agree that it is very important to involve armed groups in the discussion around contemporary challenges and the protection of their environment and the ways to address these challenges. So maybe quickly, how does Geneva Code do that? So first, I would like to highlight up front, and this may be a bit disappointing for some, Geneva Code does not currently have a standalone thematic engagement on the environment. So as you may know, Geneva Code follows a thematic approach, which means that rather than engaging armed groups on the panoply of IHL rules and humanitarian norms, we try to focus on very specific thematic areas, starting from the issue of the ban of anti-personnel mines, but also talking about other issues such as the protection of children from the effects of armed conflict, etc. And our work is really expanding to tailor to all of the newly arising thematic issues and challenges that we face on the ground. So currently, as I mentioned, we do not have an environment as a standalone thematic, but we have integrated it in our humanitarian engagement, most notably looking at our work on the prevention of starvation and conflict-related food insecurity. So we are currently still looking at ways to strengthen, and this is why we also welcome this discussion today, ways to strengthen our tools that we use for engagement on this specific thematic. So going back to the way Geneva Code operates, and in order to improve the conduct of armed groups in armed conflict, we work on various levels really to build the knowledge and understanding of armed groups, of key humanitarian issues, and adopt and support them in the adoption of relevant policies and work on their implementation of these policies in practice. And we do that through a wide range of tools, the most prominent one being our deed of commitment, which is an innovative tool developed by Geneva Code that allows armed groups to publicly pledge respect for humanitarian norms and then be held accountable for their commitments. So often these commitments go beyond legal obligations and beyond IHL per se, and include also a range of good practices. So in that sense, the deed of commitment is signed by the leadership of the armed groups and is countersigned by Geneva Code as a witness to their commitment, and also signed by the government of the Republic of the Canton of Geneva as a custodian. So the idea is really to try and bring some visibility to the group's commitment to these humanitarian norms, where the subsequent follow-up from the side of Geneva Code, looking at the implementation of this deed of commitment on the ground. So last year, we developed a new deed of commitment on starvation. And in the process, we also consulted armed groups on the content. And it is maybe interesting for you to know that all of the respondents have actually flagged environmental degradation and the impact of food security as a major concern, mostly in relation to the contamination of agricultural fields and water sources. So look, the deeds of commitment of Geneva Code are one of the tools that we use, but we also have other tools that we can rely on to engage with armed groups. One of them may be the review of their internal rules and regulations. This can include their codes of conduct. We support them maybe with looking at their internal orders, for instance, but also we are looking at ways to strengthen their commitment, maybe through unilateral declarations, or helping them in establishing internal mechanisms to ensure that they can comply with IHL. So in that sense, I want to give a couple of examples of areas or armed groups we've engaged with in the past. For example, in Mali, the MNLA has included, which is a movement for the liberation of Azawad, they have included in their code of conduct the protection of the environment. As well, for example, the Chin National Front, which is a group active in Myanmar, they have also included a provision that actually prohibits the use of weapons that can damage the environment over and just to make sure that these are avoided. So the use of weapons that can damage the environment over a long time should be avoided, and this is something that they have included in their internal policies. Moreover, armed groups that exercise control over territories often also set up administrative structures to safeguard the environment more generally. And it is interesting that in that context, armed groups have also flagged that the conflict in itself is also often an obstacle to environmental protection. And we need to keep that as well in mind. So I think Vanessa referred to that, saying that conflict, environmental degradation, and climate crisis exacerbate each other. And that's also something that armed groups have brought forward as well. So maybe as a conclusion, looking at our work as Geneva Call, I think it's important to recognize that legal frameworks are a vehicle for strengthening protection, but there is also a need to engage in a discussion while looking at different frameworks of reference. This could be, for example, reference to religious values that can be used to reinforce the messaging. For instance, Islamic norms that protect the environment are often used by armed groups as an example to show how protective Islamic rules of war actually are. Moreover, AGDAs often, so armed groups and de facto authorities, often bear a sense of responsibility for the territories they govern or the population living in their areas. So how can we build on that as well? And also not forgetting the local and indigenous ways of protecting the environment, which can be reinforced in many of the contexts. So I think Vanessa has also outlined the idea of looking also at the different aspects that drive some of the activities. It may be for economical reasons or other aspects that may have to be considered. So really understanding the interests of armed actors and trying to couple that with the interest to protect the environment and see how we can bridge the gap in terms of protection of the environment. So I will stop here and happy to take questions.
Okay, thank you a lot. Great with some practical examples as well for about how different armed groups deal with this question. I can say actually that we are preparing another policy brief on exactly this issue. We try to look in different places to see how different armed groups actually position themselves, or if they position themselves in relation to the environment. While we're waiting for more questions, there is, and we're talking about non-state armed groups. I think maybe we could, there's a question for Vanessa actually about how the ICRC currently or in future planning seek to incorporate these guidelines into their advocacy to non-state armed groups. What efforts exist to begin to train them on these expectations? So let's ask Vanessa and we'll return to Iba.
Sure, and thank you, Hiba, as well. It was really great to hear of these practical examples. I would maybe give apologies. I believe that the doorbell is ringing in my house. How exciting. So in terms of what the ICRC is planning to do, we have a unit which we call our Armed Forces Unit, and their primary purpose is to engage with weapon bearers. They typically do this with state militaries, but they also do it with non-state armed groups. And generally what they do is train them on IHL or on specific thematics related to IHL. So as part of our rollout of the guidelines on the environment, we developed a presentation specifically on the environment, which our armed forces delegates can use with both state militaries and with non-state armed groups and sort of adapt depending on the level and the capacity of the group. I would say very realistically that what that looks like is 1 or 2 slides which just clarify that the environment needs to be considered when groups are fighting, recalling the prohibition of pillage, really building in at a fairly basic level the fact that the environment shouldn't be damaged as groups fight, and should be a consideration that they take into account as they do civilians, schools, hospitals, and so forth. So we're integrating it, I would say mainstreaming it in that way in our dialogue. And the second thing is that Hiba mentioned, which I think is a really interesting piece of work that is very relevant to many of the conflicts that the ICRC works on, is exploring the protection of the environment through Islamic law and Islamic principles. And we have a colleague, Dr. Ahmed Al-Dawoodi, who's the ICRC advisor on Islamic law, who has been working precisely on elaborating how Islamic law does take the environment into account, specifically in the law of armed conflict, and has held a couple of workshops with Islamic scholars on that issue, precisely because it is a topic that speaks to many of the armed groups that in the context where we work.
Thank you, Vanessa. There is a question, I think it is for you, Hiba. It says, is there already any implementation of local practices into the protection of the environment? Now, you gave some examples of more like doctrines of some armed groups, but is there actually also some practices? We all heard also before that there is insufficient actual practice to actually make a big thing out of it, but I guess that's where we're going.
Exactly. So I think I have mentioned a couple of examples where there were already some policy commitments, I would say, in terms of the protection of the environment, but we are also continuously looking into the ways we can really implement it in practice. And this may look different in the different contexts, right? So in contexts where we are more engaged with the group and have been engaging for a longer period of time, it may be different than with groups with whom we've just recently started engaging. So this is something that, as I said, is we don't have currently a standalone thematic on the environment, so it's a bit difficult to pinpoint some of the implementation that may have occurred, but we are really prioritizing that over the next couple of years. At least within the MENA region, I can say that this is a high priority for us, and obviously the implementation will look different for each group, also depending on their capacities, depending also on the level of control they have in a certain territory. But concretely, I could not give concrete examples at this moment about some specific implementation. So hopefully in the coming couple of years, we will have more examples that could also lead to maybe in a longer run, also looking at guidelines that can really support that work as well.
Thank you very much. I guess it's also a question of actually having the focus on these practices. So they might be there, but nobody would have, seen or discussed it. I think Jairo might have a question for you.
Yes, thank you, Hiba, for the interesting talk. I would like to ask you about the acronyms. The Geneva Code started using a armed non-state group, ANSA, and then you jumped into the non-state armed groups, and now you're using these armed groups and de facto authorities acronym. Can you tell me a bit more what's behind all these developments in letters? And how do they resonate with the language used in legal policy developments by the ICRC and the principles as well? Thank you. That's the first one. I have several more.
Yes, thank you. So Geneva Code has been around for over 20 years now, and we have started with the word or the acronym ANSA, which is Armed Non-State Actor. And it was really centered around the idea of clarifying that we do not engage per se with state militaries, right? So now after 20 years and looking at really the diverse landscape of armed actors present in the various areas where we operate, and also how they perceive themselves, we have looked at the need to maybe reframe the way we address these actors. So rather than really pinpointing that they are non-state, we try to refer back to IHL terminologies, which usually refer to organized armed groups, and hence we are back at the terminology which is more considered also more neutral, of just saying armed groups rather than armed non-state actors. And obviously looking at many of the actors we engage with across the region, in the MENA region, but also in other parts of the world, is also the fact that they see themselves as even more than de facto authorities. So they see themselves as the government. They really have control over wide parts of the territory and a big number of a wide part of the population as well. So in that sense, really trying to revert back to a more neutral approach without us classifying them as state or non-state, and really referring to the fact that they are armed, and oftentimes also that they do exercise a certain level of authority. In that sense, the responsibilities also have to align. So this is where the revisiting of the terminology is coming from. But obviously this was a long process, and we have consulted many of our stakeholders in that sense, and this is where we are at today. So rather than using ANSA, which is armed non-state actors, we are now using AGDA, which is armed groups and de facto authorities.
Thank you very much. Maybe, Jairo, just one more small question for Hiba, and then we go to the general discussion.
Could I ask you a question, actually? Would that be within the bounds of the reason? Yeah, just a question about implementation of these policies generally with the groups and authorities that you work with. So we've seen examples of where a de facto authority will make a very progressive environmental statement for a particular audience. Like in our new convention for the country, we will set up and support protected areas, for example. And then simultaneously in the course of the ongoing conflict, they will have much more dubious environmental behaviour and environmental conduct. And I guess national authorities and de facto authorities are not monolithic, but there's potentially less sort of policy cohesion in less organised groups. And do you find that to be a particular problem for trying to promote IHL implementation of others with such groups, and how do you get around it?
So I mean, we've been around engaging on a various range of thematics, and I think we can apply what has been in the past also to the potential engagement on the protection of their environment. So as you said, it really depends on the structure of the group and how they are motivated, right? So that also links into, are they really organized? And then the command structure is such that if there is a decision at the top, everyone will be implementing it, or is it more loosely structured? And how do they operate around that? So there is an assessment of the typology of the group, I would say, and then how can we really address the issues that we know will come up? If it's a more loosely structured group, how can we really address that? And then the other way around, if it's a bit easier because there is a clear guidance and then a clear internal mechanism to monitor. This is really, it's the ideal scenario, right? And we try to in any case, when we engage, we try to reach an area, at least a minimum of follow-up from our side, but also of internal ownership of the process. So sometimes you have to go around looking for religious norms, sometimes more social norms, sometimes also with the support of the communities in those areas, being those affected, and they can also have an impact. So we don't only engage with armed groups, but also often are involving the community and these accountability efforts, let's say. But really it may be very varied across the countries and the actors we engage with. So how we move around it is really a good assessment of what's the situation and what are the issues we may encounter, and then a frank and open discussion with these actors about these issues. and understanding the underlying causes and how we can address them. Because if they are willing to take that step, and we can support in that, that's what we really try to do with our transparent humanitarian engagement, getting to the root causes of what's actually the issue and how can we support to remedy.
Cool, thank you very much.
Okay, thank you. Let's go to the general last end of the session. There is one question for all the panelists. So it says, what about your experience of media and taking up the issue? The media and art and taking up the issue, both playing an important implementation role, for example, through film festivals. So who would like to start?
I give the floor to Doug.
Thanks, Vanessa. Yeah, I maybe just thinking about general media interest in this topic. So over the years we've been working, yeah, obviously I think Ukraine's something of an outlier, right? Because it's very visible. It's had such a kind of profound political effect, regionally, at least for us in Europe. But in terms of the media narrative and the amount of visibility, I think with each conflict that comes along, there's a greater level of visibility around all the issues in the conflict, and particularly environmental issues, and that's changed quite dramatically over the last 10, 20 years. And I think for Ukraine, we're almost seeing like the latest peak of that visibility for these issues, and that's translated into a great deal of media interest, and that's been fantastic for bringing visibility to conflict in the environment, which isn't generally a priority for a lot of people when they think about conflicts, because people don't make the connection that the environment is a humanitarian issue. So in that respect, I think ensuring, particularly for the environment, which tends to be neglected, ensuring that it has media coverage and attention in popular media, but also potentially in art and other formats, then yeah, I think it's vitally important for the topic more generally, and certainly for any hoped for implementation of rules to protect the environment, because if we're not aware of these issues and impacts, then people aren't going to see the value in implementing these rules.
So what about you, Hipa? Well, how does it look from in the Middle East? Is there any, public discussion or awareness or interest in these issues?
Generally speaking, I think there is a global trend, I would say, but if we're trying to link it a little bit more to our work, I think there is a lot of attention when armed groups are willing to pledge, for example, to take specific steps towards the protection or humanitarian norms in general, and this would include also the protection of the environment. So I think more generally in the MENA region, if I want to just highlight more globally, I think there is an interest, obviously, in environmental protection, and it has come to the forefront how conflict is actually exacerbating some of the issues, and we have a lot of issues around access to water, for example, as well in the area in our region, which are often very mediatized and very politicized. So I think this is an issue that we will see more and more in media. So now I think the question was also referring to film festivals, and I think that's a very good way to bring attention to some of the aspects. Unfortunately, it's a bit far from the type of work that I do personally, although I think there would be an added value in also bringing the diverse areas together to advocate for those humanitarian issues.
Okay, thank you. Vanessa, you have anything to add?
Maybe just briefly, because Doug and Hiba really covered the most important points, I think. I think that another place that increased media attention is coming from is the climate crisis. And that's very positive, because the climate and environment crisis are very much interlinked, but often the climate crisis takes more space. So I think for us as a community of practitioners, it's about looking for the link between climate and environment and making the point that they're very much interconnected in how they affect civilians, and they certainly overlap, but they're not exactly the same, and they need slightly different or slightly more policy responses. So yeah, I would say it's certainly more interest in the media, including because of the climate crisis and the fact that that is being quite well covered, certainly not enough, but there's more attention, and just making the point that the environment should be understood as a part of that, and conflict as being really the front lines of both of those things, that countries affected by conflict are on the front lines of environmental degradation of the climate crisis as well.
Okay, thank you very much. We have one question, maybe of a more legal character. So it says, what is the interaction between the principle, the Prague principles, and the development of ecocide and rights of nature legislation? I guess you and Essa might have something to say there.
That's a really good question, and it maybe speaks to the fact that there's so much attention globally on the environment at the moment, and that's a really positive thing, and it's about trying to harness it into real policy change at national level. So on ecocide, I would say, first of all, to understand about ecocide is that it's broader than armed conflicts. So the general discussion that is being spoken about, for example, in the context of the ICC statute and the sort of draft principles or the draft definition of ecocide, is broader than armed conflicts. So these principles that we are speaking about at the ILC are linked to conflicts or are more narrow. With that said, the ILC principles do speak about ecocide in the commentary. Specifically when they speak, I think it's principle 13 or one of the principles on principle 9 on state responsibility speaks generally about accountability for environmental harms, and it's about state responsibility, not individual responsibility like ecocide, but it does say that it's without prejudice to any criminal liability relevant to individuals for environmental harm. So it speaks about ecocide as a potential way for accountability to be put in place at domestic level in the commentary on Principle 9. And from the ICRC perspective, the Principle 3 of the ILC principles speaks about states taking effective legislative, administrative, judicial, and other measures to enhance the protection of the environment in their domestic context. So taking their international obligations and putting them into their domestic law so that they can be enforced. That ecocide might be one way that a state interprets how it wants to do that. So how it wants to interpret its international obligations into its domestic law. It would be broader than armed conflict, but nevertheless it could cover armed conflict. And indeed, some states have already done that. So some states, in particular the previously USSR states, many of them have ecocide within their domestic law as a crime against peace. So I would say ecocide is linked to the principles in that way. It could be interpreted to be one way that Principle 3 is put into practice in domestic contexts. And then separately on the rights of nature, it's such a good question. And I would say, the rights of nature, in my understanding, is about the fact that the environment might have legal personality in and of itself, separate from humans. So an intrinsic value to the environment, not an anthropocentric approach that only values the environment for how it is useful to humans. And I would say that there are many principles in the ILC's work that reflect that intrinsic value of the environment. I think for the ICRC, that is our approach in the conduct of hostility rules, that the environment is civilian in character, regardless of whether a human is living on it today. So it is intrinsically protected as civilian in character. And I would say specifically with regard to, you can tell that I'm sort of scrolling through the principles right now. Principle 12, which is the Martens Clause, speaks about in cases not covered by international agreement, the environment remains under the protection and authority of the principles of international law derived from established custom, the principles of humanity, and from the dictates of public conscience. And public conscience is something that evolves with time. And that's where I think the rights of nature, that's perhaps where we would see it develop under the dictates of public conscience and how the environment is protected by the dictates of public conscience in time to come. It might be that it's in the commentary, I'm not sure. Thanks.
Okay, Hiba or Doc, you have anything to add? It was a very extensive, solid answer.
Maybe just yeah, two things, I suppose. One is that the Parrot principles are, they've been developed over pretty much the last 10 years, but they're in some ways like a snapshot of what we were talking about. So with the International Law Commission, it's codification and it's progressive development. So they can codify what's already there, and in some areas they can progressively develop some things. So for example, the principle I talked about earlier about business operations in areas affected by conflict, which is the little bit edgy progressive development. But at the time, there wasn't the definition of ecocide during the process where the ILC were developing the principles, and again the rights of nature debate was kind of just discussing, so it wasn't something which could be included in the principles themselves. But it kind of speaks to this point about our constantly evolving understanding of the environment and the need to make sure that the policies and protections that we give the environment in relation to conflict is also constantly evolving. And so the ILC principles are kind of a foundation stone, but again, we have to build on it. We have to keep this conversation going because there are these fields of laws and approaches which are always developing and could be applied to conflict settings.
Okay, thank you. I think time is running out, so it might be hard to start on a new round of questions, and we don't have any more from the audience. So I think I'll leave it here and thank the panelists for sharing your insights and your knowledge, and also to Jairo Munive for organizing this event. Thank you very much.
Cool. Thank you very much for having us.
Thank you, everybody.
Thank you.
Thank you
very much.